On the record in the matter of the people of the state of Michigan versus Jamie Lynn Gerard, file number 21-00488 and 23-01680. Also appearances.
The prosecutor Pete Petrowski on behalf of the people.
Assistant Public Defender John Lee on behalf of Jamie Lynn Gerard.
Okay, Mr. Red, can you hear me?
Yeah, I can hear you. It's kind of vague, but I can hear you.
You said it's kind of vague.
Yeah, it's kind of vague.
Okay, I don't know if the deputy can turn up your volume or not, but I'll try to speak.
Okay, I can hear you. It's just the pictures that I'm seeing are cutting in and out, but I can hear you.
Okay, sounds like there's a connection issue in the jail.
Okay.
If for some reason you can't hear me at any time, just raise your hand so we can know that, okay?
Okay.
Today's the date and time that was scheduled for jury trial. My understanding there's going to be a plea.
That's correct, Jim. I have the plea sheet for that. May I approach?
Yes. Okay, the offer from the people is that the defendant will plead guilty in file number 23-1680 to an amended count 1 of attempted retail fraud.
Yes,
They
ma'am.
will dismiss the charges in files 21-00488, and there is a sentencing recommendation versus a Killebrew.
Yes, ma'am.
I'm talking to the prosecutor.
Oh, I'm sorry.
Our office has been moving to a policy of using more specific language because Killebrew can encompass both sentencing agreement as well as a
I
recommendation.
just want to make sure that's clear. Okay, so there's a sentencing recommendation of no upfront jail. That's complete and accurate understanding of the plea offer, Mr. Lee.
Yes, Your Honor.
Ms. Gerard, that's your understanding of the plea offer?
Yes, ma'am.
Okay, and you want to accept that, ma'am?
Yes, I do.
Raise your right hand.
I can't raise my right hand. I've got it in a cast.
Oh, boy.
She's usually in her
But I can unhook it.
right shoulder, so she can't raise the arm.
I can unhook it, raise it. A little bit. That's about as far as I go.
No problem, ma'am. Just take your time. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes.
And you can put your hand down, ma'am.
Yeah,
Are you all right?
I'm okay.
Okay, if you need a moment, I can call your case and give you some time to collect yourself.
No, I'm all right. Okay. Just sore.
I can imagine. You're all right now?
Yeah, I'm fine. I've got my composure here.
Okay, very good. Okay, Ms. Gerard, before you can accept this offer, I need to make sure you understand some of your rights, and I need to hear that you are willing to waive those rights, okay?
Okay.
Okay, you have the right to the presumption of innocence. So that means, ma'am, you are innocent until proven guilty. Do you understand that right?
Yes, ma'am.
Okay, you have the right to require the prosecution to prove your guilt. They do that by proving each element of the charge being brought against you beyond a reasonable doubt at a jury trial.
I understand.
You have the
that.
right. Okay, you have the right to remain silent at your jury trial and not have silence be used against you. You understand that?
Okay. Yes, I understand that.
You can waive your silence at your trial and testify on your own behalf. You can call witnesses to testify for you at trial, and you can present evidence at trial that you believe show a defense to the charges being brought against you. You also have the right to confront in court and cross-examine any other witnesses that the prosecution calls to testify against you. You understand that?
Yes, I understand that.
You're willing to give up each of those rights?
Yes.
Is anybody threatening you to get you to give those rights up?
No, no, ma'am.
Has there been any promises made to you to get you to waive your rights and plead guilty?
No, ma'am.
Are you currently on probation or on parole?
No, ma'am.
Do you understand that a guilty plea in this file could result in a conviction that you may need to report to your current employer or on a future job application?
Yes, I do have a job waiting for me.
Okay, and you also understand that a guilty plea could result in a conviction that may have impact to any travel or immigration status that you may seek in the future.
Yes, ma'am, I understand that.
And understanding that you still want to waive your rights, correct?
Yes, ma'am. Yes, yes, Your Honor.
Are you seeking to plead guilty because you believe you're guilty?
Yes,
As to the amended account one and file number 23-01680 to attempted retail fraud under MCL 750.356DA, how do you plead?
I plead guilty.
Actual basis, counsel.
Thank you, Your Honor. Mr. Gerred, were you on or about December 2nd, 2022 at the Meyer store on 6200 South Pennsylvania Avenue?
Yes, ma'am. Or yes, sir. Sorry.
That's okay. And that is in the city of Lansing and the county of Ingham, correct?
Yes. Is that you? Is that my lawyer?
Yes.
Yes, ma'am.
Okay, it's you. I can't really see. It's far away. Okay, yep.
Okay. And while you were there, you did attempt to exit the store without paying for some items that you had in your possession, correct?
Yes.
I didn't hear your response.
Yes, yes. Can you hear me?
Yes, okay, thank you. No further questions, Your Honor.
Any questions from the prosecution?
No, Your Honor, thank you.
Court is satisfied with the factual basis. I'll accept your plea and find your plea to be made freely, voluntarily, and intelligently. File number 21-00488 will be dismissed per plea agreement. The victim in this matter being Meyer, any objection to immediate sentencing?
None, Your Honor. There's no restitution on the file.
You can proceed to allocution.
Thank you, Your Honor. Mr. Gerred has been dealing with some substance use issues that contributed to her actions in this particular matter. She has accepted responsibility for it. I believe she has served, I don't have the number of days, but she served some time on this matter, Your Honor.
I served almost 3 months.
And
It's
would
60
like to-
some days, 65 days, something like that.
She
And
served-
would like to.
I'm sorry, she served what?
She says she served 65 days. I
When?
have to- just now, while she's been waiting for this to get to a plea point. She was picked up, I believe, on a bench warrant. So I will have to calculate and give the court the exact number of days. But she has accepted responsibility here. She has served some time. And she does have a job lined up when she gets out, and would ask the court to consider that in a sense.
There's a $75 crime victim rights fee that will be assessed, plus a $50 state minimum cost that will be assessed. Assessing a fine of $312. When are you gonna make payments on that?
I raised my hand. I was wondering if you could give me about a month and a half to pay it because I get paid every 2 weeks. And by the time I get my check, it'll be about a month. So I'm asking for about a month and a half to get all this paid.
How much you gonna make on your first payment? How much is your first payment gonna be?
I can make, did I hear you say $50, then $75, then $300 of something?
Yep, $312 plus 75 plus 50.
I can pay 75, in like a month. And then from there, I can pay the rest of it off after I start getting my checks.
Okay, I'll note here, because your total is $437, that you will make payments of $75 a month, beginning the 17th of next month. You'll make a payment of no less than $75 each month by the 17th until paid in full.
Yes, ma'am.
Do you have any questions?
No, ma'am.
Any additional matters for the record, counsel?
Nothing from the people.
Nothing for the defense.
Okay, you're all set. Mr. Lee, are you on
But I
Dismissal?
see with my.
Excuse me, ma'am?
I was wondering if I get to speak with my lawyer when I'm done with this, like. Or how do I mean.
Your
what's-
lawyer's gonna be tied up in court. He can
Oh, okay,
schedule time to come and visit you.
okay,
Thank you.
yep, thank you.
Thank you. Is Sinoco Bti present?
Yes, he is.
On the record in the matter of the people of the state of Michigan versus Sinoco Bti, file number 24-00383, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of Sinoco Bti.
And do you have an interpreter?
Yes.
Can you raise your right hand? You solemnly swear or affirm that you will interpret the matter now before the court completely and accurately and not divulge confidential communications, so help you God.
Yes, Your Honor.
Thank you. Today is the date and the time that's scheduled for final pretrial on a domestic violence.
Sema leo ndio siku kwamba tulipanga kwamba tukutana kwa hii kesi ya kupigana.
We have witnesses here.
We do, Your Honor. The victim was here this morning with her advocate. She just very recently, within the last week, had a baby. And so she is, I believe, sitting down in a conference room. But she's been present. Mr. Lee knows she's here. She's been participating.
Sema kwamba ni mwenye aliumizwa, alikuja hapa, alipata tu mtoto karibu kwamba ni naye anaumwa, lakini yuko hapa ndani anakaa sehemu na msaidia alimuona kwamba yuko hapo.
We proceed.
Unfortunately, Your Honor, we have not been able to reach a resolution and we will be proceeding to trial.
Sema kwamba ni tatizo kwamba na hatujamaliza hizo habari leo kwamba tunataka tuende mbele tuje tusambeane.
This was currently scheduled for trial July 2nd at 8 a.m.
Kwamba ni walipanga tayari kwamba ni tarehe 2 mwezi wa 7.
Not address that, did they? Administration, because. This is Judge Simmons, quick question. Are we following juries the week before? Okay, thank you, Fine. Okay, they're not calling juries on the weekend of the 4th, so we need to get a new trial date for that. August 13th. Trial will be August 13th, 8 o'clock in the morning in person at the court.
Sema kwamba nitakuwa mwezi wa 8 tarehe 13 saa 2 kamili ndio nitakuwa narudi ile rendezvous inaachana nayo.
For the record, was there an offer on this?
There was, Your Honor. It would be for Mr. Vezimana to plead guilty as charged to count 1, domestic violence, with 76948.
Sema kwamba ni kulikuwa kwamba ni usaidizi wote wa kusema kwamba ndio unaweza chukua hizo habari, mwanasheria kule anasema ndio kulikuwa hiyo kwamba anachukua ile alimpiga mtu.
There's no objection to 76948, but the offer was to plead guilty to the original charge. So he's declining that offer. We will proceed to trial.
Sema kwamba kwa vile uliambiwa hizo habari kwamba ni wewe ukasema ndio mimi sijampiga, utaenda mbele.
Do you have any questions, Mr. Bisamani?
Kuna swali yoyote? No question.
Any additional matters for the record?
Nothing from the people.
Nini yoyote mnataka kuongeza? Anasema hapana.
Nothing for the defense, Your Honor.
Hayo hana yoyote
You're
ya
all set.
kuongeza. Tumemaliza.
On the record, in the matter of the people of
You
the
wanna wait
state
for
of
your-
Michigan versus Jamie Cottenham, file numbers 24-00899. Council appearance, please.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee, appearing on behalf of Jamie Cottenham.
It was the date and the time that was scheduled for a final pretrial and a PA 53 contempt bond violation hearing. How are we proceeding?
We have reached no resolution, Your Honor. We're proceeding to trial.
Your witnesses here.
Yes, the complaining victim as well as the officer who handled the bond violation. The officer who handled the bond violation is also present.
Okay, so we're ready to proceed on the violation.
Yes, we are.
Okay, I'll call the case in just a moment. You can have a seat now. On the record, in the matter of the people of the state of Michigan versus James Minor, file number 23-03620, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of James Minor.
Today's the date and time that was scheduled for final pretrial on a domestic violence. How are we proceeding?
The complaining victim in this matter has failed to appear this morning.
Mr. Lee,
The defense will request a dismissal, Your Honor.
motion to dismiss is granted without prejudice. The people do have the right to reissue the charge against you within the statutory time frame. Okay?
Yes, ma'am.
Okay, you're on tether right now?
No, no,
Sorry?
no, no.
Why aren't you on tether?
Got taken off August the 4th.
You got taken off August the 4th.
April the 4th.
Taken off by whom?
You.
No, that's not in my bond order. I have a bond order removing you
It
from
was for
tether.
the, it was on the felony cases. You took
This
off.
file, you were arraigned, not by me. You were placed, it says GPS tether with victim notification. It is on the form. You were not supposed to be removed off tether
My,
on this file. You may have been removed on another file. You were supposed to be on tether on this file.
I didn't.
The defense request. Okay. We'll get you a copy of the dismissal. You'll be all set in just a moment, okay? Thank you. On the record, in the matter of the people of the state of Michigan versus China Nicole Roberts, file number 23-03624, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of China Roberts.
Okay, today was the date that was scheduled for a final pretrial for an assault and battery. You have necessary witnesses here.
The victim, I believe, was on Zoom previously. I don't see her at this moment.
What's the victim's name?
Necia Nickens. Oh, there she is.
Present on Zoom. Okay. Was there an offer?
There was, the offer was for Ms. Roberts to plead guilty to a disorderly person jostling and excuse me, to an amended count 1 of a disorderly person jostling.
Mr. Lee, how did you find one to proceed?
Ms. Roberts is declining that offer and is prepared to proceed to trial.
Matter scheduled for jury trial, July 9th at 8 o'clock in the morning, okay? Okay. You have gum in your mouth? Don't chew gum in court, okay? You have any questions? Okay. We'll get you a copy of your notice to appear. We'll see you in person on July 9th. Any additional matters for the record?
Nothing from the people.
Nothing for the defense, thank you.
Thank you. Was Jerry King supposed to be put on, or is he downstairs?
Yeah, let me call and see if they got him.
On the record, in the matter of the people of the state of Michigan versus Jennifer Venn, file number 23-02304, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Jacob Rowling on behalf of Jennifer Venn.
Date in time set for final pre-trial on an assault and battery. Was there an offer?
There was, Your Honor, the offer would be for Ms. Venn to plead guilty to charge with a sentencing agreement to no upfront jail.
At this time, Your Honor, we are declining that offer.
You said plead guilty as charged, you said?
Yes.
Okay, this matter is scheduled to proceed to trial on July 9th at 8 o'clock in the morning. I don't know how many we have. This is the oldest one. This is the priority case. So your case is expected to go before her case. Do you understand that? Is that a yes?
Yes, ma'am.
Okay, so you be here on time, and we'll be ready to proceed with trial at that time. Any additional matters for today's record?
Nothing from the people.
No, Your Honor.
Thank you. You're all set. Since Mr. Green, I don't see you on here. Yes, because it's at 9. Okay. They didn't bring your client over.
I checked with the jail and they show on the list, they do not show that she was rated out Lee County.
Let's see. Oh, you can't. Definitely has a Ritz tag on the top of it. Nonetheless, we'll reset this matter so that they can bring her over. You know how long she's in Eaton?
She's been in Eaton County since April, I looked at this morning, April 24th, April 25th.
Okay. We'll reset.
She was there on a probation.
Does July 2nd work for me at 9?
Does July 2nd work for you at 9 a.m.?
It does work.
Okay, we'll do July 2nd at 9.
Great, thank you.
Thank you. Did we print a notice for Ms. Roberts?
That's what I'm looking for now.
You can release your victim if you need to.
Thank you.
Okay, let's see. On the record in the matter of the people of the state of Michigan versus William Lee Green, file number 24-01431, council appearance.
People, Your Honor, last name KOUTSIOKIS. Pursuant to Michigan Court Rule 8.120 under Paige Trotsky as supervising attorney.
She's got to be your supervisor. Motion for limited practice under court supervision is granted. Who's representing William Green?
That's Mr. Raleigh. He's speaking, I think with his Roberts right now.
That's Robert's case has been called. He needs to speak to the judge now. Roberts is right here. He's speaking to who?
Oh, you know what? I'm so sorry. Miss Ben.
Oh, okay. Sorry, that should have went over his file.
Rally on behalf of Mr. Green.
Okay, today's the date and the time that was scheduled for a pre-trial on a brandishing. Was there an offer?
Yes, Your Honor. The offer was a global resolution with a DV that is currently in the 55th District Court or 55th District Court. The defendant would plead guilty to domestic violence first offense in that file. The defendant will forfeit any and all firearms. The brandishing charge that should be today's file will be dismissed following the plea. And in accordance with the plea, we will not reissue the domestic violence first offense as a domestic violence second offense, as there is a prior.
Mr. Raleigh.
My client intends to request final pretrial as well.
Final pre-trial on brandishing. We're just having a jury trial and having a final pre-trial. So he's declining the offer.
Correct.
August 13th. August 13th at 8 a.m. is the trial date. You must appear in person, okay, Mr. Green?
What day is it?
I can't hear you.
So what day is that?
August 13th at 8 o'clock in the morning.
Okay.
You need to appear in person. There won't be a final pretrial on this, so you have up until 1 week prior to August 13th to accept the offer. Do you understand that?
Yeah.
Any additional matters for the record?
Not from the defense, Your Honor.
Not from the people.
You're all set, Mr. Green. On the record, in the matter of the people of the state of Michigan versus Lonnie Harper, file number 23-00988 and 23I53636862. Council appearance.
Can I speak to this for the people, Your Honor?
Jacob Rally on behalf of Mr. Harper, who is not present today.
Mr. Harper's not present today. Why not?
Well, I wish I knew, Your Honor. Unfortunately, I don't have a good phone number for him either, so.
Okay, let's see. Mr. Harper, that's a bit of a history, not appearing. We have the same number from May that we had a year ago for him. Are you saying the number is disconnected?
Tell you, last four digits of the number I have is 8730.
That's the number we have.
Again, here we want to call it.
Okay, I'll issue a bench warrant. The record in the matter of the people of the state of Michigan versus Mary Jean Carris, file number 19-03855, council appearance.
Assistant Prosecutor Peter Kowalski on behalf of the people.
Good morning, Your Honor. Melanie Albiwanji, attorney for Ms. Harris, was appearing by Zoom.
Interview. Today was the date and time set for a review on a forensic interview. The last update I had was that she was supposed to have a interview or an evaluation in person on Wednesday, January 17th. Did she participate in that?
Your Honor, we did not receive any notice on that one. However, she has an interview set up for the 26th at 1 p.m. This 26th of June 26th at 1 p.m.
Okay, so there's one June 26th.
Yes, Your Honor.
Okay, we will set this for another review. July 30th at 10.
Thank you, Your Honor.
Thank you. Any additional matters for the record?
Nothing from the people.
Nothing for the defense, Your Honor.
Thank you.
Thank you.
Thank you.
Radio, where's the radio? We're gonna put the radio on, no? The jail didn't put on the radio or.
Yeah, they said they were getting Jerry Keane.
They're an hour and a half late for that. Let's see. On the record in the matter of the people of the state of Michigan versus Casey Michelle Webb, file numbers 23-00222, 223, 224, 225. Council appearances.
Jacob Riley on behalf of Casey Webb, who is not here.
Riley, it's not looking good.
I agree, it's another case where.
What's your benchmarks? On the record in the matter of the people of the state of Michigan versus Cameron Haynes, file number 24-00680. Council appearance.
Assistant
morning, Your
Prosecutor
Honor.
Keith Petrosky on behalf of the people.
Good morning, Your Honor. Edith Wellenbreck on behalf of Mr. Cameron Hayes, and we are both appearing by Zoom today.
Okay, today's the date and the time that's scheduled for sentencing. I have a pre-sentence report and recommendation. It was prepared June 11th, 2024. Did you get a copy of that?
We
Yes,
did,
it is.
both Mr. Haynes and I have reviewed it. Thank you.
Any need to make updates, corrections, or deletions?
No, we are good with the report. Thank you.
Okay, you can address the court on sentencing.
Thank you, Your Honor. After talking with Mr. Haynes, he is he's an employed, upstanding member of his community. He has a home. He does share a son with his with a mother who was the victim. She has since moved out of their home. He has paid her enough money to be able to get her own apartment. They do share a 5-year-old, and he does pay freely $500 a month for the support of their child through Zelle, and that is not court ordered. And so based on that, Your Honor, we are asking that regarding the parenting time for this young son who's about 5 years old, that Mr. Haynes be able to have a drop-off point with the victim, whoever's dropping off the child remain in the car, and that whoever's picking up the child take the child from the car, so that there would be a minimum of interaction between the parties. At this point, there's no texting either, and we're wondering if that would be something that the court would be amenable to facilitate the parenting time between the parties. Because this is a first-time offense. The parties have been together for 10 years, and now they are not living together for the first time. Also, the defendant is an electrician. He works in the state of Michigan under the Brotherhood Union of Electricians. He is full-time employed, and he's been able to always support the family, and he is very, very remorseful for what happened. He just wishes it didn't happen. He is very compliant and wants to complete probation best he can. There is one other issue. As a member of the Electricians Union, there is mandatory training that occurs twice a year, and the next one occurs in August from the 25th to the 29th. It does take place in Chicago, and he does have paperwork to show his probation officer where it is, how to attend, and the dates to attend. And we're asking at this time that Mr. Haynes be permitted to attend that so it doesn't jeopardize his job. And we just all know what happens when a dad loses his job. So we would ask for that accommodation at this time also. There's another accommodation we're asking for. Mr. Haynes also has a licensed doctor's marijuana medical card. And the use for that card is for his anxiety, and it's on an as-needed basis. And we're asking this court if the defendant is able to comply with that medical marijuana card. And that's it, Your Honor. Thank you.
So you didn't have a victim, did you?
No, Your Honor. I tried to contact the victim several times and was unable to make contact. so she's not present today. Following that, I've been unable to speak with her about what she would like to see happen with the status of the no contact order. So I would just be asking the court to leave the no contact order as is until probation is able to find it appropriate to modify the no contact order.
Probation is not going to track down your victim. If she didn't want to come to the sentencing and participate and give a statement, I have no reason to believe that she wants us to continue the no contact order.
That's fair. I'm just making that request.
Okay, sounds good. Thank you. Let's see. Did Mr. Haynes want to state anything at all?
I just want to say that I take full responsibility for my actions that day. I've been fully compliant with everything since March. And I just want to go through probation and try to get back to normal. And thank you, Your Honor.
No problem. I reviewed the pre-sentence report and recommendation. I've also reviewed your prior criminal history where there's no other public convictions. Is appropriate based on what I've heard here and what I've read in this file to grant sentencing under 769.4A. So I will grant you sentencing with that special status for 6 months while on probation. I will modify the no contact order. There was previously, during the time or the pendency of this, a only third-party contact regarding the child. The court does not engage in, this court that is, does not and deal with parenting or custody related issues that would need to be dealt with over at the family court if you had specific issues that need to be addressed there. I will, however, allow there to be peaceful contact with the alleged victim, Denise Cox, well, the victim in this matter, Denise Cox. Peaceful conduct is pretty self-explanatory, but it can be easily misinterpreted. So if there is anything that law enforcement would believe to fall outside of that, that could be a violation of your probation status. You understand that?
Yes, ma'am. Thank you.
Okay, and so if you don't believe that you can communicate or engage with the mother of your child in a manner that is peaceful, then you might want to continue the third-party contact, but the court's not going to order that at this time, okay?
Thank you, Your Honor.
While on probation, you're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to use, purchase, or possess alcohol, marijuana, or controlled substance unless you have a valid prescription. If you have a valid medical marijuana card, you must first turn over a copy of that to probation, and then I will amend my order then allowing you the use of medical marijuana. But as of right now, until we get a copy of that, you will not be allowed use of alcohol, marijuana, or controlled substance until otherwise prescription is shown, okay?
Yes, ma'am.
You must submit to random preliminary breath testing and your analysis testing as directed. You're responsible for the cost of that. You're not to be at any bars or any nightclubs while you're on probation. Do you have any questions so far?
Yes, Your Honor. So I do work all over the state, really. It changes from like week to week. So does that mean I have to be in Lansing all the time for a random, or will it be?
If you're ordered to test, you need to communicate with your probation officer if there is a work-related delay and why you aren't able to get to testing on that day.
Yes, ma'am.
But you can, under no circumstances, just blow off your testing because you are working in another city.
Yes, ma'am.
Even if that means that your time of testing needs to be adjusted so that if you're ordered to test, you test before you leave, or work with probation if you're going to be in an area where they can have you drop there. You need to figure something out, but you need to be in constant communication with your probation officer so that they're not perceiving you to be violating this court order, okay?
I got you. Like if I leave town or I know I'm leaving town for a couple days, let them know that ahead of time. Something
Exactly.
like that. Okay, no problem.
Exactly. And that would be the smartest thing to do because you're being proactive. You're letting them know before you're ordered, because if you wait until you're ordered and then you tell them, it might be perceived that you're evading your testing and you don't want that.
Yes, Your Honor.
As it relates to your request to travel, we're not restricting your ability to travel while you're on probation. However, if you are going to be out of town, again, because you do have orders to have testing at random, again, that would apply there too. You would let them know in advance, I gotta travel for work. So they will know not to order you for testing then. I will, however, advise you that they're likely to order you testing as soon as you get back if you're traveling, especially if you're traveling for a vacation, okay?
Yes, ma'am.
Okay. You're gonna maintain your employment while you're on probation. And I'm
Yes,
not gonna order any programming at this time. Do you have any questions?
No, ma'am.
There's a $30 per month oversight fee that you're responsible for while on probation, so that's $180. There's a $75 crime victim rights fee that you must pay, and a $50 state minimum cost that you must pay. We're going to waive discretionary fines and costs at this time. Total fines and costs is $305, and you do have the option of making monthly payments on that, okay?
Yes, ma'am.
Lastly, I just will advise you that there is an advice of rights as to when you can request early discharge from probation. However, your particular case, because you are on probation for domestic violence, would not be eligible for a request for early discharge, okay?
Yes, ma'am.
And I took that into consideration as I sentenced you, because the original or the request of probation was to have you sentenced to 9 months. I'm only sentencing you to 6 months, okay?
Yes, ma'am.
Do you have any questions at this time?
No, ma'am.
Okay, you will also make sure you connect with probation to make sure they have accurate information with you. You can call them just to confirm that the information they have for you is correct. They need to now take this order and draft it for your review, and then you'll sign off and begin your probation, okay? Do you have any more concerns? I'm sorry?
Will they contact me or my lawyer about when I have to start going into probation?
They're gonna contact you. Your lawyer has, when we finish here, she has done her duty on this. So it's now your responsibility to make sure you're in communication with probation, okay?
Thank you, ma'am.
No problem. Counsel, did I miss any of your requests? Because there were a lot.
I know, and I thank you for your accommodation to Mr. Haynes. The other thing is, does the probation office have an email address that we can submit that marijuana card?
Which is Jody Bayless.
Okay, he would want to send it to Jody Bayless, who I believe is going to be his assigned probation officer. Let's see. And it's Jody, Jodie .Bayless, BAYLIS @lansingmi.gov.
Thank you very much. Nothing further, Judge.
Thank you. You're all set. Good luck to you both.
Thank you.
Thank you.
That's Mr. Keene. Who's representing Mr. Keene?
I am representing Mr. Keene.
On the record, in the matter of the people of the state of Michigan versus Jerry Anthony Keene. File number is 23-03585. Council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Public Defender John Lee on behalf of Jerry.
Mr. Keene, can you hear us?
Yes, ma'am, I can, Your Honor.
Okay, today's the date and time set for a final pretrial on the domestic violence. Do we have witnesses here?
No, Your Honor, I didn't make the guilt okay this morning.
How do you want to proceed, counsel?
Defense makes a motion to dismiss, Your Honor.
Motion to dismiss is granted without prejudice. So that Mr. King, that means that the people do have the right to reissue the charge against you, okay?
Yes, ma'am.
Do you have any questions?
No, ma'am, I don't.
Any additional matters for the record, counsel?
Nothing from the people.
Nothing for the defense.
You're all set, sir.
Thank you, Your Honor.
You're welcome. Tremaine Hopes here
Yes, Your Honor.
on the record in the matter of the people of the state of Michigan versus Tremaine Hopes. File number 24-00023, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Jacob Rowley on behalf of Mr. Holmes.
Okay, Mr. Hope, today's the date scheduled for sentencing. Counsel, I do have a pre-sentence report that was prepared on June 11th. Did you go for the copy?
Check in here. Yes, I did.
And students.
Yes.
Do you need to make corrections, updates, or deletions?
Not on behalf of the defense, Your Honor.
You can make allocation.
Your Honor, I do want to begin by saying that the recommendations in the pre-sentence report are fair and appropriate, and I would ask that the board have those recommendations on behalf of Mr. Oaks. I also want to say that I think it really, he has had a number of legal issues in recent years. He wants to put those issues behind him to get them resolved. I know there's a few traffic matters that he still needs to take care of in other courts. Your Honor, certainly he's trying to get his life back on track. And he, well, I can tell you that he is seeking new employment and certainly actually trying to better his situation. I think with recommended domestic violence counseling, a period of supervision, that can help him get closer to that goal. Your Honor. That would be my mistake.
Have you taken care of your warrants?
I probably wasn't even aware of being there were warrants. About time
You probably wasn't aware? What does that mean? I probably wasn't aware? You can't recall
At
if
the
you were,
time, I didn't know that it was a warrant.
what did you think it was?
I wasn't told, like, I wasn't given nothing, just like a ticket. And some of the times they just brushed it off, so I didn't even know that it became something major.
These are tickets, different tickets though, correct?
If I'm not mistaken, yes. I'm aware of
What do you
two,
mean that they just brushed it off?
because I didn't get no, I wasn't told that I had to go to court or something like that. I was just given like a citation or something like to pay a fee.
Did you pay the fee?
No,
So what you think was gonna happen to, you think the ticket was, or the citation just evaporates over time?
no, I tried to stay in contact. They told me to come in person. I actually tried to like, which I knew that result was gonna be, and I didn't have the time to do all that.
What was the result that was gonna be?
Being incarcerated. And I
For a
had the
traffic
time.
ticket? You don't know that. We don't, and this was in 2020. I can bet dollars to donuts, no one was putting you in jail for traffic tickets in 2020. The only reason why you have the, and they're bench warrants is because you won't take care of them. So you gotta put a warrant on to make you take care of it. It's like unnecessary supervision of our adults. We won't take care of it, so we'll have to lock you up to make you take care of it so you can take care of it. When all you gotta do is turn yourself in. If you took yourself over to that court, and it looks like it's 37th and 36 that you have these pending, and said, I want to take care of these, they would set you up and you wouldn't have to sit in jail. you'd walk out the same day. And Mr. Raleigh could have told you that too. Nobody's keeping you in jail for traffic stuff. Take care of your business.
Yeah, I tried though, but like I said, I was just in fear of being incarcerated and not having the time to be prepared.
They're traffic tickets. No one's keeping you in jail for traffic tickets. You will be kept, you are more likely to be kept in jail if you don't take care of it, and then you end up getting locked up or stopped because you're in Detroit hanging out. And now you're gonna be locked up because you got the warrants. You wanna go and take care of it. There's a presumption when you turn yourself in that we don't have to lock him up to make him take care of his business. We'll give him a next court date. That's the presumption that you only have if you turn yourself in to the court, say, hey, I have these and I want to get them taken care of. Yeah, get them taken care of so you can move on. So we don't have to keep seeing these. Are you still working at Wendy's?
I'm actually, no, I resigned.
You resigned because you got another job?
No,
Why did you resign?
it just wasn't fitting for me. It was too unorganized and don't nobody want to work, you know. So I gave them a flexible schedule to allow me to come in and do whatever, however, and it seemed like that was still putting a burden on me and making it hard for me because don't nobody want to come in. Like we sitting outside 9 in the morning waiting on managers, somebody to come let us in. It was just tragic. I'm getting changed on the schedule without being notified. So I'm coming in and I'm paying for lifts and rides to get there. And it was, you know, it's hard to try to like stay there, you know, without being notified properly. Great communication on what's going on. Why am I being changed on the schedule? And I'm just popping up and all of a sudden I don't have to work, you know, it's just hard, you know.
So what's your plan for work?
I got an interview today at the Myers Warehouse, and I have one Thursday for conveyance, canvasser, like signing petitions. I mean, since I was working at Wendy's, I've still been doing interviews, like for the job in, after the job in, doing the job.
Any additional allocution before we proceed with our sentencing? I've reviewed the criminal record. I've gone over it with you. It's mainly traffic matters that you need to just go take care of so that they're not lingering over you, and especially if you want to get a new job, so that you can have that behind you and it's not hindering you. You understand that?
Yeah, so I have the opportunity to take care of that.
Yeah, you need to take care of it. You're going to be required to take care of it. You contact 36th District Court. You probably need to go down there and tell them that you're here because you had a bench warrant and you want, I couldn't tell you where the cases are, but you need to get it taken care of. Because if you're anywhere within 25 miles of those courts right now, if you get stopped for anything else, the order is to take you into custody to address it. You shouldn't have to be taken into custody to address it. You should bring yourself in there, get a court date so you can go home and then appear for your next court date. You understand that?
Yeah.
And then you have one in Central Line, 37th District. So take care of both of those. Especially while you have some extra time on your hands and you're waiting for your new job. The order of the court is that you will complete a term of probation. Are you currently on probation though?
Yes.
Until when?
I actually gotta go to court next month. I think if I'm not mistaken.
You're on probation until August?
Yes. It was only 6 months.
I'm gonna put you on 6-month probation as well, actually. While on probation, your first requirement is address your warrants. In 30 days. By the time you have your report, I expect those warrants to be clear. Do you understand?
Yes.
Did you finish high school?
Yes.
You're gonna obtain employment and provide proof of that to your probation officer. You were accepted to the National Guard.
Yes, I think I blew my chance because of this, and this was like my second time, like actually trying, so. Yeah, I'm devastated about that, but my
What do you mean you
chance,
think you blew your chance? Did they tell you that?
she never reached back out. She came all the way here. I mean, I did my fingerprints, we took pictures together, I did paperwork, I guess the background. Pissed her off, the background check, so. She
Did
came
you
all
reach
the-
out for a status after you didn't hear back?
Yeah, I reached out to her. She didn't reply, so I just assumed that she was mad.
It's unfortunate. It's a constant reminder of how our decisions can impact our future. But it's not for you to think that you can't get back on track, because you can, but you just need to make better decisions. You're young. You look healthy. Make better choices. Let's see here. It says you owe $1,063.89 for what?
I got my high school diploma online, so I'm just carrying like the transcripts, and I have like email letter from the proof of Cam Foster, which is where I got it from.
Got it.
So I just got like the documentation that just verifying that I actually completed the high school diploma.
Okay. And do we have a victim here on this?
No, Your Honor, I tried to reach out to the victim, but was unable to make contact.
I'm going to continue the no contact order with Ms. Porter at this time. You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess firearm, ammunition, or weapon of any kind while on probation. And you're not to use or possess alcohol, marijuana, or controlled substance unless you have a valid prescription, okay?
Yes.
You're going to be required to submit to random testing. That's PBT and urinalysis testing, and you're responsible for the cost of that. Nothing, I'm sure that's different from your other probation that you're going to be completing, okay?
Yes.
I won't order any additional programming at this time. There is a $30 per month oversight fee that you're responsible for while you're on probation. I'm ordering you to 6 months, so it's $180. $75 crime victim rights fee plus a $50 state minimum cost that you're responsible for. And I'll waive discretionary fines and costs. So your fines are only $305 and you'll make monthly payments on that, okay?
Yes.
Okay, what are the two things outside of the other conditions that I order that you must do while on probation?
I need to get that tickets to the
And
the job.
very good. Okay. Do you have any questions for the court?
No.
Go over my order once probation prepares it. When you leave here, go downstairs 1 level, check in with probation because they want to make sure they have accurate contact information for you. So once the order is done, they can get it to you for you to review and sign. Okay?
Yes.
Any additional matters for the record, counsel?
Nothing from the people.
No, Your Honor.
You're all set, sir. There is a Charlotte Barker here. Is anybody representing her?
I think we did not have a.
Might be representing herself. And then I see Carlos Torrance. Who's representing Carlos Torrance? Carlos Diaz Torrance. Mr. Raleigh. Who's representing Mark Rosales?
I am representing Mark Rosales.
Are you ready on Rosales?
Yes, we are.
On the record in the matter of the people of the state of Michigan versus Mark Anthony Rosales, file number 23-00857. Council appearance.
Good morning, Your Honor. My name is Makena Al-Musawi, and I'm requesting permission to practice under Michigan Court Rule 8.120 under the supervision of APA Paige Petrowski on behalf of the people.
Permission granted.
Thank you, Your Honor. Assistant Public Defender John Lee appearing on behalf of Mark Rosales.
Mr. Rosales, can you hear us? You're muted, by the way. I need you to unmute your device. Can you hear us? I can't hear him. I can't hear you. We'll go off the record why he never.
Can you hear me now?
Not you, I'm talking to Mr. Rosales. Did you hear me talking to him, Mr. Rosales?
I can hear you talking, but it's really faint.
Thank you. Okay, I can hear you now. It's your device, so you probably need to adjust the volume.
Okay, I just put it on speaker.
Okay, sounds good. Today was the date and time set for a pre-trial for domestic violence. How are we proceeding?
So we were planning an offer for pleading guilty to domestic violence. Third with 769.48 if elected.
Is there a domestic violence third?
It was the
or plead guilty to the charge?
Yeah, guilty to a charge.
To the original charge, okay. Plead guilty to the original charge, no objection to 769.4A. How does your client want to proceed?
We'd like to set the matter for a final pretrial, Your Honor.
Pre-trial July 23rd at 8 a.m. July 23rd at 8 a.m. In person at the court for final pre-trial. Jury trial August 13th. Jury trial is going to be August 13th at 8 a.m. in person at the court. Do you have any questions today, Mr. Rosales?
No, I do not.
Any additional matters for the record today, counsel? You're all set, Mr. Rosales.
Okay, thank you. Have a great day.
Same to you. Ms. Barker?
Yes, ma'am.
You declined a court-appointed counsel, correct?
Yes, ma'am. That's what I was advised.
Okay, so you're gonna represent yourself?
Yes, ma'am.
Okay, we'll see if the prosecutor can meet with you in just a moment. Mr. Lee, do you have anybody here ready to go? To jail.
Hodo Brown.
I do not have anybody here who's ready to go other than Ms. Cottenham. I do need to speak to Mr. Hodo Brown.
Who's in the jail?
Antonio Heredia.
Thank you.
I need to speak to him very please, bro.
Okay, you need to speak to Heredia. You have to speak to who else?
And Hodo Brown. They're both incarcerated.
Hodo Brown's not on now. Cottenham, you said, what about Cottenham?
She's here. She's ready whenever you want to proceed with the PA 53.
Okay. Okay, who else is waiting? Because we have other people in the courtroom, and I'm not sure if they're waiting for court.
I'm Darl Fields. I have a show called.
Okay, sounds good. What's your name, ma'am?
Carly Campbell.
Okay. Who's representing Campbell?
Proceed on Ms. Campbell anytime you're ready to go.
On the record in the matter of the people of the state of Michigan versus Carly Campbell, file number 24-0111, 1113, and 1114, council appearances.
Natashi, could you just for the people?
Assistant Public Defender John Lee on behalf of Carly Campbell.
Okay, all of these files were set for pre-trial today. And I have one that is a dog at large, one that's a vicious dog, and one that's a dog license violation. How are we proceeding?
Yes, Your Honor, I believe the offer was dismissed upon showing compliance, and I believe we have received a proof of surrendering of the dog to animal control. I just want to verify that I'm not getting my case mixed up and that there was only one dog, or if there were two dogs that both were surrendered.
Your Honor, in regard to the dog that was at large and such, that was the dog that was surrendered, and we provided proof of that to the prosecutor. Ms. Cottenham, I'm sorry, Ms. Campbell has a license for the other dog. I haven't seen the proof yet. She tells me she has the proof. As soon as I see it, I'll forward that on to the prosecutor as well.
The dog vicious habits getting dismissed for a license?
No, I believe the dog vicious habits is the one that was surrendered as well.
That is the one.
Okay. So the people are dismissing the dog at large and the vicious habit.
Yes, because those have been surrendered. Because that dog has been surrendered.
Okay, and so you're waiting on the proof of the license on the other one, is that it?
What I understand.
That is correct.
Okay, so we'll reset that. July 2nd at 2. July 2nd at, you said what time, 10? 2 at 2. Actually, give me another date because. Okay. July 9th at 8:30. July 9th at 8:30. Do you have any questions today on that part? No. Okay, people. City of Lansing versus Carly Campbell, TG 23006833. This matters in show cause status because you owe $102. Parking violation. Gonna pay.
I could pay half on Friday.
You're gonna pay the balance. Friday is. Y'all note that here in the filing. So long as you do that, it won't go into warrant status. Okay. Any additional matters for today's record, counsel?
Nothing to the defense. Your Honor.
Thank you, you're all set. And then Mr. Lee, you can go meet with other people, and then I miss Petrosky or your designee, if someone can meet with Ms. Parker.
Yes, Your Honor. Yeah, do you know how to, you know what you're doing? Yep, yeah.
And on the record, in the matter of the people of the state of Michigan versus Darl Fields, file number 17-05219. Fields, let me see here. This matter is set for show cause because it looks like you had some fees that you never paid. Not reading the previous judge's handwriting, but it looks like you owe $604.50.
On destruction of property.
Correct.
Honestly, Your Honor, I've kind of just been getting my life back on track. I just got my first apartment. I was recently homeless for a while. I just kind of put everything else aside, and I just, been getting everything else together. But I can start paying on that. Today is my 4th day doing teach-out security. I was just working fraternity behavioral services, and I was a DSP there. And I just left for a higher pay doing the security job. Some of my sites that I work at is the Ingham County Youth Center, the hospital, auto owners insurance company. And I did make a payment plan a while ago that I never fell through with. So I do take full responsibility for that. I can start paying $20, $50 a month or so. Right now I'm just, being a single father right now, I'm just working. The property was, I was young.
You have custody of your child?
Joint custody. He stays in Nebraska. I gave him for the
You said what?
I have joint custody. He stays in Nebraska.
You say you're being a single father.
Single father. Like I have him for the summer. Like so, I'm just being a single father right now. But
You're being a father.
Yeah, I'm being a father.
Thank you. Okay.
I am in trying to get full custody though right now because there's a lot of things going on.
I don't want to hear about it, but you said that you were being a single father, and I just wanted to delve into that a little further because I wanted to know if you have custody or was there child support. You owe restitution in this. It's really my major concern. I've understood the previous judge's note now that I looked into the file. She arranged you, it appears, and waived oversight fees for probation, and your updated balance is 604 because it under Judge Clark was 715, and that included fines and costs, crime victim rights fee, and state minimum costs. But the restitution that owed is $240, and you've owed that 6 years. How would you feel if I owed you $240 for 6 years?
I'll be more than upset.
You think I would care that you have a kid?
No.
How old is your kid? So you owed money and you made children. You didn't take care of your responsibilities, did you? Okay. When are you gonna pay this person the money you owe them?
I'm not gonna get it to them, pay the whole full off by the end of July.
Okay. I'm gonna note here that you're gonna pay the full balance of $240 by the end of July. If you do that, you stop in to see me and I'll waive the balance of the fees that you owe. Otherwise, if you don't do it, you're gonna get a warrant and then you're gonna have to pay all of it. Which one do you want to do?
I prefer the first option.
Thank you. Have any questions?
Do you see any other fines or anything like that to pay? Like,
we can look it up. They should have. It would have been pulled for today.
Because I'm going to get my license today, and I'm trying to make sure I don't have anything.
He has one, he has two, but I don't know if they. So that he can. Got a speeding, it looks like you owe 155. And stop sign violation, you owe 180. Is it, they're not, it doesn't, you don't see a suspension on there? Post office return non-deliverable. Late penalty. You have two old, those, they're from 2021, so they could, I don't see it on our end that Secretary of State has suspended, but I would not be surprised if they have.
Yeah, I had a ban that was up on the 15th, the Saturday that just passed, so I was trying to make sure if I'm going there, still get my permit and everything. They told me once my ban was up, then I should be able to.
Yeah, I don't see anything on here that's saying that you're, that your license was suspended for those. Okay, at least not yet. So you want to get those taken care of as well, but right now we'll deal with that. A restitution that you owe, and you'll get that paid by the 31st of July. You're all set for today, sir.
Thank you.
Same to you. Did someone meet with Ms. Barker?
Yes.
I need to bring it back. She's there, I just need to bring it back. Who's supposed to leave me? Didn't log in, she might be meeting with me. He was supposed to be meeting with Heredia and I thought Torrance. Okay, you ready on Torrance? Okay, on the record in the matter of the people of the state of Michigan versus Carlos Diaz Torrance. And that's file number 24-016, 01062, council appearance.
Your Honor, so Taine was on behalf of the people.
Running on behalf of Mr. Torrance.
Okay. And Mr. Torrance is present via Zoom. Today was the date set for a pretrial on an assault battery. How are we proceeding?
We're going to be requesting a second pretrial conference so that we can review some evidence that we have received at discovery and do some further investigation of our own. This time there have not been any offers from the prosecution.
July 9th at 8:30. July 9th at 8:30. Do you have any questions today, Mr. Torrance?
The day was July 9th.
That's correct.
That'll be all. Thank you.
Thank you. Any additional matters for the record, counsel?
Oh,
you're all set, Mr. Torrance.
Thank you. Have a great day. Everybody else too.
We need to find Mr. Lee, because I don't know.
He's logging in now.
How come it's not showing on mine? Oh, okay.
So that was with the.
On the record in the matter of the people of the state of Michigan versus Charlotte Barker, file number 24-00648, council appearance. Ms. Barker is present via Zoom without counsel. Ms. Barker, you have met privately with the prosecution's office. How are we proceeding?
Yes,
Yes,
Your Honor,
ma'am.
Ms. Barker has showed me her license for that dog, and I verified that it's for the correct dog and has a valid expiration date, so the people will be dismissing because of compliance.
Okay, your case is dismissed. You're all set, ma'am.
Thank you so much. You guys have a great holiday.
Thank you.
Dismiss it. See, the lady already told me that. She was like, wow.
Sir, what's your name? You waiting for court date?
Pardon me?
Yes, sir.
I'm Justin Sykes. I'm looking for Cottenham.
Okay, and what's your name, sir?
I'm the waiting for the Hodo Brown.
Okay, sounds good. Oh, what is this, Mark Anthony? Oh, that's Anthony Taylor. This one is Mark Mitchell. He also did not appear to show cause.
There we go.
For the record of the matter, the people of the state of Michigan versus John Heather, file number 24-01274, council appearance.
Your Honor, subpoena was Valley on behalf of the people.
Jacob Raleigh on behalf of Mr. Heather.
Mr. Heather, can you hear me?
I can.
Very good. Today's the date, the time set for a pretrial. It's a retail fraud, third degree. Was there an offer on this?
Yes, Your Honor. Our offer was an attempted retail fraud third degree.
This time, Your Honor, we'll be requesting a second pretrial. My client and I have some things to discuss. And we'll mull over this offer. No, final decision this time.
July 9th at 8:30. July 9th at 8:30. You have any questions for the court today, Mr. Heather?
I do not.
Any additional matters for the record, counsel?
Nothing for the people, Your Honor.
Nothing from the defense, Your Honor.
You're all set, sir.
Okay then.
Mr. Ockley is here with Kornick, Michelle Kornick.
Yes.
Okay, on the record in the matter of the people of the state of Michigan versus Rochelle Kornick, file number 24-01175 and 76 and 77, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Good morning, Your Honor. Robert Ockenecki appearing via Zoom on behalf of the defendant, who's also appearing via Zoom.
Oh, today was the date and time set for free trials and 3 files, 2 for dog at large and 1 dog malicious destruction of property. How are we proceeding, counsel?
Well, Your Honor,
so-
I'm sorry, go ahead.
Oh, no, you can go ahead, Mr. Rennick.
Your Honor, I sent some emails back and forth with the prosecutor on this, and we weren't really able to talk until a few emails this morning. We actually attempted to do a stipulation to adjourn, and I don't think we quite got it done fully on time into the court. But essentially, my client's arguing that this isn't her dog, and so this should be dismissed. And I think that the prosecutor is going to investigate a little further and see if that's actually true.
I'll reset these.
July 9th at 10.
July 9th at 10.
Thank you, Your Honor.
No problem, you're all set. On the record in the matter of the people of the state of Michigan versus Cameron Jamil Fair, file number 23-02131, council appearance.
Assistant Prosecutor Kenisha Sumer on behalf of the people.
Your Honor, Dustin Cruz for Cameron Fair. I'm here in the courtroom and he's appearing by Zoom.
Thank you. Mr. Fair, can you hear us in the courtroom?
Yes, ma'am.
Today was the date and the time that was scheduled for a motion hearing. Mr. Cruz, you filed a motion in this file. And that was a motion to dismiss. I did receive a copy of your motion and I've read a copy and I have a response that was filed by the people as to that. Did you all discuss this prior to me calling the case?
Yes, we did, Your Honor.
Okay, just by nature of the people's response, it's clear that they're conceding that count one should be dismissed, correct?
That's correct, Your Honor.
And
And
you have a nollie in the file.
Yes.
Count one will be dismissed. So that leaves count two, which is charged as careless discharge. You make any argument you have at this time pertaining to that one in here.
Thank you, Your Honor. And just before I get into the merits of the argument, I would like to make it clear just prior to the court calling this case this morning, Ms. Petrosky and I were talking about possible resolution of the case. And in light of that, I will be brief in my argument. I think everything I want to argue is contained in the brief, but just to let's give the court an overview. We're asking that count two also be dismissed for three different reasons. One, the conduct alleged here does not rise to meet the statutory language that my client is being prosecuted for. Secondly, I think at worst, the facts here show slight negligence, not ordinary negligence, and slight negligence is not enough to be convicted under this statute. And thirdly, as applied to this particular case with these particular facts, I think prosecution would violate my client's right, Second Amendment right to keep and bear arms for self-defense in his own home. On the first point, and I should note to the court, I believe the people in the defense more or less agree on the facts here. The facts here are my client owned a pistol for which he also had a CPL. He was in his own apartment with some friends of his who were over for the night. He set his pistol down on a pool table. Subsequently, he bumped the pool table. The gun fell to the ground and it discharged. With those facts, I don't think the people can demonstrate that the gun was under my client's control, which I think is something that is more specific than even constructive possession. I don't think I illustrated this in my brief very well, but I kind of think about it in the way someone might need to have a vehicle under control to be prosecuted for operating while intoxicated. It's not enough that they're in the car. It's not enough that they're in the car in the driver's seat with the keys, but they have to actually exercise some physical control over the car, even though the car might be in their possession. I think that's an analogous situation to what we have here, that the gun was not under my client's control at the time it went off. Further, I don't think he certainly factually caused the gun's discharge, but proximately, I don't think that people can show that here. He bumped into a table, the gun fell, and then discharged. Secondly, assuming that makes a prima facie case for prosecution under the statute, I think it shows at worst slight negligence from my client's point of view. He set the gun down on a pool table and then it subsequently fell off. It might be different if he had small children running around the house. I'm thinking about it in the same way. If I put a wine glass near the edge of the table while my daughter's running around and then she knocks it over, perhaps I was negligent in the placement. But if it's just me and some adult friends and somebody bumps the table, I don't know that I'm negligent in the placement of that wine glass. Lastly, an as-applied Second Amendment violation. Here, my client possesses a gun lawfully in every sense of the word. He's licensed to carry it concealed, even. And he's in his own home, which is where the core right for self-defense under the Second Amendment is. That's where it's at its strongest. People have a right to keep loaded guns even in open spaces in their home, and so could he have taken greater precautions to prevent this from happening? Absolutely, he could. But did he need to, and should he be required to, in light of the Second Amendment and in light of the Supreme Court's decision on the Bruin? No, I don't think the court or the prosecution can require that of him. I'm asking the court to dismiss him too. Thank you.
Ms. Petrowski.
Thank you, Your Honor. First, I just want to state that in a motion to dismiss prior to in a pretrial proceeding, the question is generally whether there is sufficient evidence for a trier of fact in this either a jury or bench trial for a trier of fact to make a finding beyond a reasonable doubt. And there really has not been any real argument that there isn't sufficient evidence, at least that there is a question of fact for a jury to make a determination from. In regards to whether the firearm was under defendant's immediate control, the statutory, there is not a statutory definition of the immediate control of the defendant. However, consistently in criminal case law, the terms control and dominion or having dominion over something are used somewhat interchangeably. And based upon the existing case law, it's very clear that the firearm was in fact under the control of the defendant. He does not necessarily have to have it literally within his hands, but he would have to have both the legal right to possess the item and the authority. And then also, which is still narrower than than just a all-out determination of constructive possession. In this case, defendant did have control over the firearm at the time it was discharged. He was the legal owner. It was legally present in his own residence. He is the one who placed the firearm in its location on the edge of the table. He is the one who knocked the firearm off the table. We have not heard any argument or evidence that defendant was not the person who was the one who loaded the firearm. And he's the person who's responsible for making sure that that firearm is stored and kept safely, whether it's on his person or in his residence. And in addition, after the firearm discharged through the wall of his neighbor's apartment, he took efforts showing that indicate he took a sense of responsibility for the fact that that gun was his own and that was his own actions. He went to try and talk with the neighbor. He went and alerted the building manager, and all of those taken together would suggest, at the very least, that there is sufficient evidence for a jury to find that he had control over the firearm. When it comes to whether he or whether his conduct rises to the standard of ordinary negligence, as we've both stated, there's not really a dispute as to whether or not he's a factual cause of the firearm firing. But the people's contention that he is in fact a proximate cause because the consequence, the gun firing, was the direct and natural result of his actions. There were no intervening causes that were unforeseeable to the defendant. It is incredibly foreseeable that if you leave a loaded firearm without the safety mechanism in place on the edge of a table, and then you are acting in such a way that would knock that firearm off of that table, it is reasonably foreseeable, given people's general understanding of how gravity functions, that firearm has the potential to discharge and, in this case, fire through into his neighbor's dwelling. Finally, I just want to say, when it comes to the Second Amendment argument, in terms of an as-applied analysis, in this matter, the state governments are permitted to make laws and enforce laws regarding the use of firearms surrounding the use of, but it may not infringe upon the rights of law-abiding, responsible citizens. The legislature is permitted to define essentially what is legal or law-abiding conduct. And one of the things they explicitly outlawed was negligent conduct in this statute. So given that they have the ability to make these statutes and this conduct falls directly underneath that statute, I don't believe that there's any valid Second Amendment violation here.
I haven't already addressed the fact that the first count is going to be dismissed. We're looking again only at weapons, firearms, careless discharge of a property damage, discharge property damage, that is. And so the people would need to prove beyond a reasonable doubt that the defendant did, because of his carelessness, recklessness, or negligence, but not willfully or wantonly, cause or allow a pistol under his control to discharge and destroy or injure the property, in this case of an Eric Foreman. And I've heard your arguments, Mr. Cruz. I find them to be flawed, because your argument hinges upon the fact that this is a true accident. I'm not disputing, and I don't think that the prosecution would dispute that it's an accident. It doesn't mean that it wasn't caused by carelessness. Carelessness can cause accidents. Recklessness can cause accidents. We see that in a number of circumstances and scenarios where carelessness could lead to that. I think carelessness as it relates to possession and ownership of a firearm should reasonably lead you to believe that it could lead to some to an accident of carelessness and accident of recklessness. But in this particular case, you made a correlation or tried to make a correlation between a wine glass. We're not dealing with a wine glass on the side of the table. We're dealing with the allegation of a dangerous weapon. That I don't know if this weapon is one that had a safety, but if it did, was the weapon properly secured with the safety? How many people were in this house? I don't even know how old are the people in the home. You're placing a firearm on the edge of a table when you have people here to socialize and drink. A number of things that could go wrong crosses my mind. You refer to this as just a true accident, and I see it grossly different. This is a major accident, in my opinion, because of all of the possible ways in which that could have gone wrong. And I agree with the prosecution's argument that, again, the person who allegedly hit the table causing it to fall is also the person who possesses it, owns it, and has the responsibility to secure it, and the person who would have been responsible for putting the safety on it if you were going to leave it there. There was just a number of ways that this could have gone wrong. And thankfully, at least according to this information, there was no harm caused to anybody else. But the question of whether or not the way that he possessed the property, and whether or not it rose to the level of carelessness or recklessness or negligence, there's more than enough to believe that there's a question of fact for a finder of fact. And so there isn't sufficient evidence or information before this court to grant a motion to dismiss, so that matter will continue. Your motion is denied.
Thank you, Your Honor.
Thank you.
I'm sorry, did I provide an order?
That was my next question. I don't see. Oh, I do see an order. A copy of the order, and then let's see, do we have the next court date? I think it's up for jury trial August 6th. Are we still continuing to jury trial?
Your Honor, I don't know the answer to that. If my client could stay on Zoom, the court might be able to recall this matter yet this morning for a resolution.
I can probably set it for a pre-trial in between there. I'm not calling the case again this morning because I have another hearing I need to hold, and there's some other people that are waiting, and it's already almost 11 o'clock. Except for July 9th. You have a final pretrial July 9th, so you'll have time to discuss even with the prosecution if there's a further offer. So I know that the original offer included pleading guilty to count 2, but that may have been at the time that they weren't moving to dismiss count 1. And so you can discuss further offer and proceed to go over that with your client before that July 9th date, okay?
Very good. Thank you, Your Honor.
Thank you. You're all set. You're all set, Mr. Fair. Okay, ready. Let's see. Mr. Lee here?
Yes, I have.
Okay. You met with Heredia?
Yes, I have.
On the record in the matter of the people of the state of Michigan versus Antonio Heredia, file number 18-05847 and 24-01168. Council appearance.
Council, could you just for people?
Assistant Public Defender John Lee on behalf of Antonio Heredia.
Okay, I have a driving while license is suspended in file number 18-05847, and the other is a malicious destruction of property. How we proceed?
Yes, Your Honor. For the first case will be an offer has been made to plead guilty to an amended charge of allowing a suspended person to drive. He's unable to obtain a license. And for the second case, I believe we need to speak with the attorney on one of his felony cases for a potential resolution.
Mr. Lee, how do you want to proceed?
Your Honor, we would ask to go on ahead and just set the matter for a final pretrial. The prosecutor is exactly correct. Mr. Heredia has never had a license, but believes he can get one and is expecting to be released within the next couple of weeks. The MDOP charge was, we thought was being handled as part of the plea on the felony case. There has been a resolution and a plea on the felony case, but I am not sure if the MDOP was a part of that resolution, so I have to follow up on that. So we could either adjourn for another pretrial or set for a final pretrial.
I'll adjourn for another pretrial. July 9th at 10. July 9th at 10. You have any questions today, Mr. Heredia?
No, ma'am.
Any additional matters for the record, counsel?
Not for the people, Your Honor.
Nothing for that.
You're all set, sir.
Thank you.
You're welcome. On the record in the matter of the people of the state of Michigan versus Jamie Cottenham, file number 24-00899, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of Jamie Cottenham.
Are we ready to proceed with the bond violation hearing?
People are ready, Your Honor.
Yes, the defense is ready.
You can call your witness.
Thank you. The people would first call Mr. Justin Sykes.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes.
You can have a seat, Mr. Sykes. Can you state your first and last name and spell both?
Justin Sykes, JUSTINSYKES.
Thank you, Your Honor. Morning, Mr. Sykes. Thanks for being here. What's your relationship to Jamie Cottingham?
We were friends for a really long time, nearly a decade, and then for the past year, we were roommates.
And are you aware of any pending legal matters against Ms. Cottingham?
Other than this one,
I was, and are you aware of this present one?
Yeah.
Okay. Did you receive any phone calls on the date of April 7th, 2024? And who was calling you?
Brother Daniel.
And how do you know her brother Daniel?
I mean, we spent a lot of time together. Most of her family. So.
And would you recognize his voice? Do you remember what his phone number is?
I was just looking up. Remember the last four is 7031. I don't remember.
And so when he, and so he called you?
He called me.
And what did he talk to you about?
He called to threaten me, essentially, saying that Jamie was over there drinking and, you know, pestering him about calling me and blah, blah, blah. You know, essentially, he just wanted to come over and fight me.
And so, to the best of your knowledge, or I guess, did he frame it to you that Jamie was present while he was calling you?
He did indicate that she was there.
And when you say he was threatening you, can you describe what those threats were?
They contained some very vulgar language.
That's okay.
But essentially, he was saying he was going to come break into my house and beat my ass, and the gist of it, and many variations of the terms.
And you said that he had told you that Ms. Cottenham had been pestering him or telling him to call you?
That is what I believe during that call. It was like a 15-minute.
And why did you believe that?
He just kept alluding to it. He never directly said it, but he was drunk, so letting him slip. You know? I'll admit he never directly said that she was asking him to call, but he did allude to the fact
Excuse me. And did during the course of that phone call, did he mention this proceeding at all?
No, he wouldn't have had knowledge of this proceeding.
And so you said the call lasted about 15 minutes?
Yeah.
Let me stop you. When you said he wouldn't have had knowledge of this proceeding, what proceeding are you talking about? This contempt court or the underlying case?
Well, I don't believe he'd have knowledge of either one of them. I don't think either court date was scheduled.
Okay, so what do you mean he was alluding? What did he say that made you believe he was alluding to something?
I can't remember the exact words. It's been like over 2 months now. But he was saying, well, Jamie's over here and she's drunk. And, she wants me to try to figure all this kind of stuff out. He rambles a lot. It's kind of hard to make sense of those things.
Figure out what kind of stuff?
Her property, the mail, why this whole situation is happening.
But you remember him saying something to the effect of, she wants me to figure this stuff out?
I'm hesitant to say that for sure.
But your recollection is that he did say that she wanted you to call about the property?
Yes. I don't remember the exact words.
Okay, but your recollection is that she wanted Daniel to call about property and mail? And then why the situation between the two girls were happening? She wanted him to find out about that?
And so what did you do after that call ended?
I called the Lance Police Department and just reported the harassment.
Why did you do that?
Mostly so that it was documented in case there were future occurrences. So I don't have to call, 2 months later and go this and this and this and this.
No further questions.
While you were having this 15-minute conversation, did you hear Ms. Cottingham at all?
I did not hear her. I believe he had stepped outside of wherever they were at, so she wasn't directly in his presence during that phone call.
Well, thank you for being here, Mr. Simmons. You have a relationship with Daniel, yes?
I wouldn't say I have a relationship with him. I've met him a number of times, holidays and things like that.
Okay. Earlier in your testimony, you said that the two of you had spent a lot of time together. Is that what you meant by that?
I guess so, yeah. I mean, he's been over to our apartment half a dozen times probably. We helped at her parents' house, Jamie's parents' house. Okay. I've seen him over the past year. I've probably seen him at least a dozen times.
And on the day that he called you, he said that Jamie had been talking to him about what was going on between the two of you.
Correct.
He said that Jamie wanted his help in helping her to figure out how she was going to get her property back and her mail and those kinds of things. But he never said, Jamie said to pick up the phone and call you, right?
Not in those exact words, no. But he did indicate that he was calling on her behalf.
Oh, sure. An older brother concerned about his sister calling on her behalf. I understand. But he did not say, Jamie said, call you and tell you anything, right?
No, he didn't say Jamie said call.
Okay.
He said, Jamie said, what he said was that he was calling me because she was asking me to find things out. Well, I guess.
I'm sorry, cut you off.
No, go
Yeah, no, I understand. Yeah, okay. So he called you up because she was upset and he wanted to find out what was going on, right? No, thank you. No further questions.
Well, that wasn't what he said. He said she was asking him to find things out. That's what he said. Correct?
I'm sorry, I didn't hear that.
That is what I said.
So he told you that Jamie told him to call you to find things out.
I guess I can't say that she told him to call.
Right.
What I am saying is that he said he was calling because she wanted him to find things out.
Okay, she wants his help and he decided to call you.
Correct.
Okay. But not because she said to call you, because he decided that's what he was going to do and how he was going to handle it, right?
I can't prove that one way or another.
Thank you.
I have no regret.
Did anybody else contact you on her behalf?
I mean, I've spoken a lot with one of her sisters. During the first couple weeks after the incident. Since then, there's been
What's her sister name?
sister.
Okay. And so how did you get in contact with Sunny?
Facebook Messenger.
You contacted her, or she contacted you?
I mean, the very first contact since the incident, I contacted her to let her know Jamie had been arrested. And then, I mean, from that point on, over the next couple weeks, it's kind of back and forth. I've had a fairly civil relationship with him.
Okay. And for Daniel Cottenham, did he have your number
He did have
previously? You all previously spoke on the phone?
Yes. I'm not sure how he got my phone number to begin with.
So
He reached out to me unsolicited.
So that when the April 7th date was the first time you recall him calling your phone?
Oh, no. No, we've spoken in the past. I think probably the first time he called me directly was 2 days after the rescue.
In that phone call.
Or you know what, actually, I'm not about that. He spoke to me, the first time he actually called me was about a week before Easter, so about a week before this incident.
Before the incident?
Yeah.
Okay. So he had your number before this incident, that's what you're saying? Okay.
I have no questions.
Thank you. This witness can be excused. Any other witnesses?
Just briefly, I'm calling Officer Mark Fox. While she's getting Officer Mark Fox, if I could ask the court to take judicial notice just of the terms of Ms. Cottenham's bond. Specifically that one of the conditions of the bond was that Ms. Cottenham is not to have or cause any third party to have direct or indirect contact with the victim just in sites. And that the bond was issued on March 30th, 2024. Thank you.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, Your Honor.
Thank you. Can I have a seat? And state your first and last name, spell both.
Mark, M-A-R-C, Fox, F-O-X.
You can proceed, counsel.
Thank you, Your Honor. Good morning, Officer Fox. How are you doing?
Good.
Where are you currently employed?
Lansing Police Department.
And were you employed there on April 7th, 2024?
Yes, I was.
Were you working that day?
I was.
Did you respond to a call on April 7th regarding Jamie Cottenham?
I did.
And what did you, how did you respond to the call?
I spoke to a protected party, I believe a PA 53 on the phone.
Okay. And I'm not going to get into everything about that conversation, but as a member of law enforcement, are you able to look up what person is associated with a specific phone number?
Yes, I have multiple avenues to look those things up.
Okay. And do you recall looking up who was associated with a specific phone number in this case?
I do.
And did you look up who was associated with the number 517-662-7031?
Yes, I did. I verified the owner of that phone number through our SRMS system.
Okay. And who is the registered or the person associated with that phone number?
I believe Daniel Cunningham.
And through the course of your investigation, did you did you learn what Daniel Cottenham's potential relation to this case was?
It was the brother of, I believe her name's Jamie Cottingham.
No further questions.
Hello, officer. Thank you for being here.
Hello, sir. How are you?
I'm good, thank you. So you went out, you took a report and you confirmed that the number that was involved in the situation belonged to Daniel Cottenham.
Yes.
Okay, and that was it. You didn't observe anything. You weren't a party.
I spoke via TX to the.
I'm sorry.
This was all done on the phone.
Oh,
So,
on the phone. Okay,
yes.
I got you. Okay, thank you. No further questions. Thank you.
So I made this witness be excused.
Yes, you may.
Thank you, officer.
Thank you.
Any other witnesses?
No, Your Honor.
This defense calling witnesses.
No, Your Honor, we are not going.
You should proceed to argument.
Thank you. The condition that it is alleged that Ms. Cottenham has violated of her bond is the condition for her to not have or cause any third party, or not to have or to cause any third party to have any direct or indirect contact with Justin Sykes. We heard testimony from Justin Sykes that he was contacted on April 7th by the defendant's brother, that he was able to recognize the voice and that he had spoken on the phone with him previously, but that it was not a frequent occurrence that they would talk, was my understanding. And in the course of that phone call, Mr. Sykes learned that the defendant was at her brother's house. They had been, both brother and defendant had been drinking, in that through indirect language, essentially, defendant had caused her brother to call Mr. Sykes in this matter for a number of reasons, but regardless of whatever the reasons may be, there is not there's no condition in her bond saying that she cannot have any contact to discuss the case or in regards to that, it's any contact whatsoever. And the fact that the brother, whose phone number is verified to be Daniel Cottenham, her brother, she asked him to find out information, or she pestered him to contact the victim, regardless of the exact language used. She, through her actions, caused the brother to contact the victim, in this case, Justin Sykes. And then not only did he contact him But he was also making threats and trying to fight the victim in an assault and battery case. And so for those reasons, I asked the court find that the defendant did in fact violate the condition of her bond.
Thank you, Your Honor. Certainly don't deny that her brother called this gentleman. The real question is, did she cause him to call the complaining witness? And based on everything I've seen and heard, the witness testified that he could not verify that Jamie asked Daniel to call him. We do not dispute the fact that Jamie was talking to her brother about what was going on in her life. We do not dispute the fact that her brother got upset and called this gentleman. We do dispute the fact that Jamie asked him to call. We do dispute the fact that it was done at her behest. The prosecutor is using language like this was indirect.
That's the language in the order.
She even went so far as to say in her closing remarks that Jamie asked and pestered her brother to call this man. There was nothing in the testimony from this gentleman that suggests that she asked or pestered. It does say, he did say that she wanted his help. It did say that she was complaining about the situation, but they have an independent relationship. This was not the first time they had spoken. They've spoken on many other occasions, and Jamie is not a puppet master. She can't control people. She can ask people to leave people alone. She can say, I'm not allowed to have contact with this guy. But if her brother gets ramped up and picks up the phone and calls this guy, that's her brother doing something. If they got a problem with her brother doing that, they should file charges against the brother and say, hey, he's using the phone to accost this guy. But it wasn't done at her behest. And he even said on the stand, there's no way he could confirm that he didn't hear her voice in the background. And that gentleman that called him never said, she told me to call him.
Okay. Just brief reader or rebuttal. It is not required under the conditions of the bond for the people to have to prove that the defendant used the exact specific language in that exact specific language requesting communication with the victim. It's not required that to show that she's verbatim asked, will you please talk to the victim in my assault case? And that the brother in this instance then had to repeat, Jamie asked me to talk to you, the victim of my assault case. That is not what the standard is. That's not what is required. What's required is that she cause, or that she could cause any third party to have direct or indirect, as the terms of the bond, contact. Based upon the testimony, and I use specific phrases like pestering and also asking, because those are the phrases used by the Mr. Sykes while he was testifying. Although Mr. Sykes was not able to say with certainty the exact phrasing that was utilized, it is very clear from the context that also Justin Sykes would have no way of knowing whether or not Jamie was present drinking with the brother if the brother had not brought that up to him. So at the bare minimum, the brother has been drinking with the victim, discussing the case, and then all of a sudden just decides out of nowhere to then contact the victim and discuss issues that would be relevant and that potentially a defendant in an assault case would want to address. So I think that there's no issue here, and regardless of I don't think that there's been sufficient evidence to find that this is an independent action completely separate from any cause by the defendant's matter.
Okay, so I had testimony today from two witnesses, but primarily a witness, also an alleged victim in the underlying matter, Justin Sykes. He testified that on or about April 7th, that he received a phone call from a Jamie Cottenham, a person that he knows to be the brother of the alleged victim, of the defendant in this matter, Jamie Cottenham. The witness testified under oath today that the brother called threatening him. He said he essentially wanted to fight him, that he was informed that the brother, Daniel Cottenham, and the defendant in this matter, his sister, Jamie Cottenham, had been drinking. He testified that Jamie was pestering Daniel about coming to fight or threaten Mr. Sykes. He testified that it was about a 15-minute phone call. In further questioning as to what was specifically stated, he was candid. He said he couldn't remember or state specifically what was said, but that the statements alluded to the fact that the purpose for the call, the reasons behind the call were because of a request of some sort from the defendant. I recognize that Mr. Sykes has testified that he can't prove, or he doesn't have evidence to prove that what, if anything, Ms. Cottenham said to her brother, whether she said to call Mr. Sykes, whether she gave out the number. We know that he wasn't there. He can't say whether or not the sister was even there, but that she was told by the brother that they were there drinking. And that their conversation had occurred. And what strikes the court as the most concerning portions of his testimony was not just that the brother called, because I'm someone that has 9 older brothers. And so if I say that anything happened to me, I don't have to go any further. My brothers are going to come to my aid. But what was relayed, at least through this testimony from the witness, was that there was questions about property and mail. My brothers, if they think that there was an issue that they need to secure me or pay retribution, are not calling about mail. They don't want to pick up my mail. They're not getting concerned about my mail. Unless I ask them, can you get my mail? Calling around trying to get people's mail without their permission, it's a federal offense. So I have reason to believe, based on those things, that there was a call, and that call was a concern about property and mail. The other concern that the court has is that there was questions about why this situation was happening. The specific terminology in the order is do not have any indirect or direct contact with Justin Sykes. In quotations, it says, or cause any third party to have direct or indirect communication. Cause does not have to be that I told you to call somebody to do it. If I told my brother, or if I'm complaining to my brother about something that's bothering me, I didn't just meet my brother today. I know that I'm inciting him, or I should have reason to know that. I know that he's going to get upset and he's going to want to defend me. And I have now a responsibility to inform my brother, unless, of course, I want him to call and find out about my mail. You can't call him, otherwise I'll get in trouble. And my brother, who's supposedly trying to protect me, correct, would not want me to get in trouble. So he used some common sense. If the call, as referenced by Mr. Sykes, was just about why is this going on, I would absolutely believe that the brother was just incited after hearing what was going on with his sister and made a call. She had no control over that, and there was nothing that she did to cause her brother to call. But this situation also involved a call about some mail. And that element right there causes me to believe that she caused her brother to call to find out what's going on with her mail and her property. I'm sustaining the violation. Violation is punishable for a maximum penalty of 93 days in jail and or $7,500 in fines, because it's a contempt of court order. When we give a court order, it's not just for semantics. We don't just tell you that because we like to run down this list of things for the purposes of filling up our day. We're doing it for the protection of the alleged victim and for the integrity of the process. And I can agree with you, Mr. Lee, in your argument that the people could charge if they believe this was happening, they could charge the brother, they could, because it's tampering with a witness. And they still could do that. There's nothing to do with her responsibility as part of this case, which is to follow every aspect of the court order. And I believe that she took steps that would cause her brother to violate this court order and make contact with the defendant. You can address the court, with the victim. You can address the court before sentencing.
Thank you, Your Honor. Ms. Cottenham maintains her innocence in the underlying case, and as it pertains to this matter, basically throws herself on the mercy of the court. She did have a conversation with her brother, and as the court has taken note, it appears that that conversation is signed with her brother, and therefore she is liable. She is a full-time employee. She is a contributing member of society, intends to defend this case vigorously throughout, and ask the court for any understanding or compassion that might have sentencing in regard to this matter, whereby Ms. Cottenham has indirectly violated a court order and apologizes for doing so.
Did your client want to make a statement?
Was that the question, Your Honor, was whether or not she wanted to make a statement?
Correct.
I did like to make a small statement. According to my brother, he does have an attitude problem. I have known in the past. He has called it on his own warrant to friends, even our family, and like the defense of the witness said, has threatened violence. So if you guys do want to prosecute him, I don't have any against that. And I'm very sorry that he did the check. I did that.
Thank you. The fact that you're aware that your brother has these things means that you have a greater responsibility when it comes to protecting yourself during this. As you maintain your innocence, you don't want to put yourself in a position where you're bringing information to your brother, knowing that he's going to get upset, he has an anger problem, he's going to react. You knew that when you were having this conversation with him. And just like I can't control my brothers, you can't control them either. I can only control my role in what I do that would incite them, and what I tell them that will incite them. That's your responsibility, so you can protect yourself and so you don't keep coming in and out of here, and so that you don't end up sitting in jail with the pendency, during the pendency of this case because you violated bond or you did something that causes your brother to place you at risk of a violation. With that being said, I'm going to sentence you to 7 days Ingham County Jail. I'm going to hold the 7 days in advance. And if there's no further violation of the court order during the pendency of this matter, the 7 days will be dismissed.
Can I say one more thing?
Yes.
On July 7th, I was at the shelter. I was not near my brother at all, and I have been sober since the date of arrest.
April 7th?
It was not April 7th. It was March 29th, I believe.
You said on July 7th you were at the shelter.
April 7th, my bad, the week after I was arrested. I was at the shelter because you have to report before you're working, because I didn't start back at work on April 27th. So I got clearance on April 5th. So I was at the shelter by 5 o'clock that day. I was not with my brother, so I wasn't aware of any of that phone call. You have to report to the New Hope Women's Shelter by 5 every day.
Thank you. Well, it doesn't appear that we'll have any further issues. I think we're clear as it relates to what our responsibilities are as it relates to the court order. We shouldn't have any issue, and you won't have to sit in jail for 7 days because of that, okay? Any additional matters for the record?
Yes, actually. There has been, and I believe we discussed this with the court at the last time we were present. Ms. Cottenham still has property that is at the formerly shared residence where Mr. Sykes is currently living. Mr. Sykes is moving from that apartment and needs to basically needs that property either moved or taken care of. And we have we emailed with the court that he has, that I believe defendant has permission to have law enforcement accompaniment to pick up her belongings. And so I'm just asking on behalf of the victim if there's been any forward progress towards that, because he does need to be out of the residence soon.
Okay, I do have a note here from May 21st. Prosecutor was to confirm that the with victim will allow defendant to come and retrieve items, and if victim intends to participate in prosecution. So apparently he's allowing her to come retrieve her items. So you all can make arrangements today.
She is prepared. She has the church set up with a U-Haul to go next week, Thursday, June 27th. If that works.
So.
No.
What day, June 27th? June 27th?
Yes, ma'am.
Okay. So the order is that she'll have June 27th to be able to go get her property.
Okay. I would, can I just ask that, or I guess ask the court, I know she'll be going with her church. If I could, we could still have an officer accompany her for civil standby, just because there are some, the victim in this matter has some concerns about certain items of property being taken that are not hers to take.
He's not gonna be there when she goes to get her stuff.
Correct. That's why I was
Why would
requesting
the officer
civil
need to be
standby.
there to watch her get her stuff if he's not there?
I thought that was standard procedure for my.
Yeah, you're allowed to go with law enforcement, I guess, when the person's gonna be there to get your personal items. But if she's moving her stuff out, he's knowing the date in advance, he's not supposed to be there so that she can go and get her stuff. Law enforcement will have no idea of knowing what she's allegedly not supposed to take. If she takes something that she's not supposed to take, that's a civil matter.
Understood.
So no, I'm not gonna tie up law enforcement to go, I don't, take her 12 hours to move for all I know. She's gonna go, he knows the date in advance, she'll get the June 27th. I don't know the exact time this church is going to come.
8 in the morning.
8 in the morning. And approximately how many hours do you think it'll take you to get
It'll
on?
take the whole day, because I do have a lot of property
They
in my
haven't packed.
bedroom and nothing's packed, and my son is gonna be there to help see outside his bedroom. So it'll be an all day thing. Roughly, usually took me 2 days, but I know we'll get 1 day before.
I'll give her the full day, beginning at 8 a.m. to get her things off the property.
Very well, thank you, Your Honor.
Any additional matters for the record?
No, Your Honor.
Nothing for defense. Your Honor.
You're all set. Okay, who's in the jail? This must be Hodo Brown. Who do we have in the courtroom?
I have Kenisha Sumer.
On the record in the matters of the people of the state of Michigan versus Kenisha Sumer. File numbers 23-01, 216, 217, 218, 219. Council appearances, please.
Honor Tina on behalf of the state.
Assistant Public Defender John Lee on behalf of Kenisha Sumer.
Okay, Ms. Sumner, how are you?
I'm sorry.
How are you?
I'm okay. How are you?
I'm doing well. We have 4 dog license cases. How are we proceeding?
Ms. Sumner is trying to get the proofs in regard to the dogs. To remind the court, the dogs were her previous partner's animals. They separated, he moved out. The dogs were in the backyard because she left them there for him to come pick them up. He never came and picked them up. Dogs got loose. The dogs were subsequently picked up by animal control and never claimed. So Ms. Sumner has been trying to find paperwork that would show that animal control took the dogs and kept the dogs, and whatever they did with them after that, she doesn't know. But she's had a hard time doing this. She's been making phone calls and such. I've encouraged her to go to the animal control office, have a face-to-face conversation, because I don't know. Animal control must have some records that shows they picked up these dogs, but this is a year ago. and she has some specific identifying information on the dogs, so maybe they can confirm that they had the dogs, but we just haven't been able to find those proofs yet. She's open to the idea of somebody from animal control or whatever coming by to inspect the property, just so they can see that she doesn't have dogs, that she's not in possession of
So
any
essentially,
dogs.
those dogs were inadvertently surrendered, is what you're saying?
Yes.
I don't know why we have two attorneys that both work for the same county as animal control, and we keep sending this lady to find out. You all find it out. You're representing her. She's not representing herself.
And that is one of the things I've recently communicated to the prosecutor, to ask them if they could inquire, because they should probably have friends over there that they get records from all the time.
Yes, Your Honor, we discussed this yesterday, I believe, and so we are going to look through and see how we can communicate with animal control as well in order to get the proofs needed. Once that's established, we are also planning on dismissing.
It was 4 dogs? Okay, and all 4 were allegedly surrendered? Okay. My concern with resetting this is what, Mr. Lee? What's my concern?
Twofold. One, will we actually have it resolved by the time we come back? 2, will everybody appear?
Not necessarily everybody, because I think you'll be here. I think the prosecutor's office will be here. But Ms. Sumner, she does come to court. And I've had this case, next week will be the 1-year anniversary of the first time you failed to appear.
So I've never dealt with a case like this, and I thought that once I paid, I thought it was a ticket. And so I paid $400, it was $100 per dog. I thought that was it. I moved and I didn't get.
Who you paid $400 to?
I believe it was this court, right? It was $100 per dog.
You got $100 PR bond on each of these files. You ain't pay a dime.
Initially?
That was your initial bond. It's a dog case. We didn't make you pay on a dog case. They all say 100 PR. If you miss court, I can see why they might make you pay. But when you were, and I don't even see if that ever happened. I see every time you got another PR bond, you got another PR bond. And I've not yet put remand just because it's dog related. And I don't need you sitting in jail for dogs. But if you don't come to court, I have to put remand. I don't know who you paid $100
to be released from jail.
So you must
get the record for that. I believe it was like $424 that I ended up having to pay.
Yeah, you paid, looks like probably after you failed to appear.
Yes, ma'am. So that wasn't for the ticket, that was just.
That's just a bond.
Okay.
But you didn't come to court, you forfeit a bond when you don't come to court. If you had came to court, then that means when the matter was resolved, you could get your money back. But if you don't appear to court, we issue a bench warrant and forfeit the bond, meaning it's no longer your money because you never came to court. And you never resolved the matter. Matter's still pending. Let's see here. And you did that online? Is that what happened? Credit card, web bond?
Yes, ma'am.
Yeah, that's because you didn't come to court you were arraigned and you had a PR bond, you never came to court, so a bench warrant was issued. In June of 2026, you paid that in December. And you forfeited that since then, because since then you've missed court 3 times. So this matter is not resolved until you either get a sentence from the court telling you how to address it, after you either are found guilty or pled guilty, or they just say that they're dismissing the case. So until you've had either a guilty plea or guilty finding or a dismissal, you have to continue to come to court. You don't even have to come in person. You can come online if you have a phone with a video capability and you're in a quiet place, but you got to come.
Okay, I was told that once you have a failure to appear, it's court policy that you can't come via Zoom.
That's not my policy. You have to come to turn yourself in on the warrant, but your next court date, you can appear via Zoom unless it's a trial or something else that you have to do in person. But this is a pre-trial for a dog case. You do not need to come in person. Okay. Do you have any other questions today?
No.
Okay, let me reset these matters. How much time does the attorneys need to track down Ingham County Animal Control? 'Cause they can be tough.
A week top.
July 9th at 10.
July 9th at 10. Okay, any additional matters for today's record?
Nothing for the defense, Your Honor.
You're all set, ma'am. We'll get you your notice to appear.
Okay, thank you.
You're welcome. Let's see. Keith Cooper. On the record in the matter of the people of the state of Michigan versus Keith Cooper, file number 24-01482. Council appearance.
Your Honor, the panel is filing on behalf of the people.
Jacob Riley on behalf of Mr. Cooper.
Okay, today's the date and time set for a pre-trial, and this for a domestic violence. How are we proceeding?
Your Honor, the people would like to offer a guilty as charged for the DV with the 769.4A.
No objection to 769.4A. Any, are you gonna accept the offer? Or do you want a final pre-trial?
We'd be requesting a final pre-trial.
July 23rd at 8.
Final pre-trial July 23rd, 8 AM in person at the court.
Jury trial August 20th at 8.
Retrial August 20th, 8 AM in person at the court. Do you have any questions today? I can't hear head nods in court.
No.
Thank you. Any additional matters for the record?
Nothing for the people, Your Honor.
Nothing from the defense, Your Honor.
We'll get you a copy of your notice to appear, okay?
All right.
Thank you.
Thank you.
I can see, Mr. Lee, you gotta go meet with Hodo Brown, because I got stuff to do today. Were you supposed to meet with Hodo Brown?
Yes.
Okay, let's see here. Or Sean Williams. What time was that set? Yeah, that's why I was asking if I was missing something, because this was stuck to that file. It does say.
Oh, that was the file we couldn't find yesterday.
Oh, got it. Well, there's that.
Excuse me?
Mr. Hodo Brown,
Yes, ma'am, I do.
your attorney is coming to meet with you. Hang tight.
Yes, ma'am. Excuse me? Yeah, Lonnie.
Mr. Hodo Brown? Mr. Hodo
Yes,
Brown?
hello? Yes,
Have a
hello?
seat. You gotta wait till I finish your case.
Sorry, ma'am, I apologize, Your Honor. I couldn't see you guys in the background and still stuck on Mr. Lee's picture.
Yeah, because you were in the breakout room, so I had to bring you back.
Okay.
You can see us now?
No, I cannot.
Okay. Mr. Lee's not there, so you still see his picture?
Yes, ma'am.
We have water out for all the herb might be thirsty. I just got a shallow can. No, don't rush. Please.
On the record, in the matter of the people of the state of Michigan versus Natashi Hodo Brown, file number 24-00574, council appearance.
Your Honor, the panel was talking on behalf of the people.
Assistant Public Defender Johnny on behalf of Natashi Hodo Brown.
Okay, Mr. Hodo Brown, today is the date set for a state matter. You have a retail fraud third degree. How are we proceeding, counsel?
Your Honor, can we permission to approach the bench?
Yes, please.
We have paperwork in regards to a plea agreement.
Okay, very good. Okay, so the people.
I think we'll have
Can
to
you
call
see us?
back, but I want to fix the screen. No, it's
Okay, off the
glitched
record.
and all digitized.
Sounds good. We'll go off the record.
There we go.
Thank you. Okay, back on the record, the people have provided you with an offer, Mr. Hodo Brown. It says for you to plead guilty to retail fraud, third degree, and pay restitution in the amount of $99.92. Retail fraud third is the original charge, so we're not amending the charge, correct?
Correct.
Okay, and you want to accept that offer?
Yes, ma'am.
Okay, please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Thank you. You can put your hand down. Okay, so I need to go over your rights with you. I think we did this yesterday. I need to make sure you understand all your rights and that you're willing to waive those rights, okay? Can you hear me?
Yes, ma'am.
Okay. You have the right to the presumption of innocence. That means that you're innocent, sir, until proven guilty. Do you understand that right to be innocent until proven guilty?
Yes, ma'am.
Did you want to give that right up by pleading guilty today?
No, I'm guilty, ma'am.
Okay. Okay, you have the right to have a jury trial and you have the right to require the prosecution prove your guilt at trial. They would have to prove each element of the charge of retail fraud, third degree, beyond a reasonable doubt. You understand your right to trial and your right to make them prove your guilt?
Yes, ma'am. I am
Do
guilty.
you want to give, and you want to give up those rights as well?
Yes, ma'am. I am guilty.
Okay. Anybody threatening you to get you to give those rights up?
No, ma'am.
Has anybody made any promises to you to get you to say that you're guilty?
No, ma'am.
Are you on probation?
No, ma'am.
Are you on parole?
No, ma'am.
You understand that if you plead guilty, it could become a conviction that you need to put on a job application.
Yes, ma'am.
And you understand that it could be a conviction that can prevent you from traveling to certain countries if you get a conviction for retail fraud third degree, correct?
Yes, ma'am.
As to retail fraud third degree, how do you plead?
Guilty.
Factual basis.
Thank you, Your Honor. Mr. Hodo Brown, on or about February 29th, 2024, were you at 3630 South Cedar Street, otherwise known as the retail establishment Mega Bev?
Yes, sir.
Okay. And that's in the city of Lansing in the county of Ingham, correct?
Yes, sir.
Okay. And did you at that time take from the store items which were for sale without paying?
Yes, sir.
Okay, and those items were specifically 2 bottles of vodka and 2 bottles of tequila, correct?
Yes, sir.
No further questions, Your Honor.
Any questions from the prosecution?
Nothing, Your Honor. Thank you.
Court is satisfied with the factual basis. I'll accept your plea and find your plea to be made freely, voluntarily, and intelligently. Any objection to immediate sentencing?
No objection.
Okay, restitution is ordered to Mega Bev in the amount of $99.92. And I'll credit you time served. When will you pay the $99.92?
As soon as I get out, ma'am, I can do it today.
Is he being held on anything else other than this?
I think this is the last thing that he had wrapped up, as far as I can tell.
Okay, I'll note that you'll pay that within the next 7 days. Do you have any questions
Yes, ma'am.
today?
Yes. So, Your Honor, thank you so much, Your Honor.
You're welcome. Any additional matters for the record, counsel?
Nothing to the defense, Your Honor. Thank you.
Okay, you're all set, Mr. Hodo Brown.
Thank you.
You're welcome.